Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning.
Good morning. Good morning, Chief.
I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. I'm sorry we're not in Richmond, in the beautiful Lewis Powell Courthouse, but we'll do the best we can under the circumstances. Our first case. Well, first, in addition, Judge Diaz and I are honored to have Judge Gallagher with us this morning from the District of Maryland, sitting on the Fourth Circuit Court of Appeals. Welcome, Judge Gallagher.
Thank you.
Our first case this morning is number 1962, August Mack Environmental versus the Environmental Protection Agency. Mr. Zimmerly, good to have you with us, sir.
Thank you, Judge. Good morning, and may it please the court. My name is Phil Zimmerly. I'm the counsel for the appellant August Mack Environmental Incorporated. In this appeal, August Mack seeks reimbursement for substantial remediation work that it performed at a Superfund site in Fairmont, West Virginia. The district court found that because August Mack did not submit a pre-authorization form prior to performing the work, August Mack may not recover from the Superfund. This court should reverse the district court's decision for three reasons. First, the EPA's reliance on the pre-authorization form violates the Paperwork Reduction Act. Rejecting August Mack's application for reimbursement for failing to submit a pre-authorization form is an unlawful penalty. Second, the district court's application of a strict compliance standard is arbitrary and capricious because it relies upon an obsolete form and ignores a primary aim of CERCLA. August Mack sufficiently alleged that it had substantially complied with EPA's pre-authorization regulations and should have been allowed to pursue its claim. Third, the district court erred in its analysis of the site-specific funds that were available under the consent decree. Turning to the first point, the EPA's reliance on the pre-authorization form violates the Paperwork Reduction Act. The PRA was designed to reduce and minimize...
Mr. Zimmerly, I'm sorry, this is Judge Diaz. I have a question, sort of a factual question, I guess. Had this project gone as your client had anticipated and Vertelis had not filed for bankruptcy, can you explain to me how you would have envisioned your client being paid under the structure and contracts that were in place at the time? I mean, you wouldn't have relied, I wouldn't think, on the Superfund to get payment, would you? But for the bankruptcy of the general contractor.
That's correct, Your Honor. I believe that was the original intent was Vertelis would have paid, but for their bankruptcy. And after they declared the bankruptcy, at that point in time, the funds were sought from the Superfund.
And where would Vertelis have received payment from? And what pot of money?
I believe that Vertelis would have paid August Mack directly, not from any fund that was created either on the Superfund or the special site funds.
Okay, so this is sort of what you're trying to do here is essentially, and I don't blame you for this, but trying to look at alternative pots of money to make your client whole. But I guess you can see that in the normal course of business, Vertelis would have paid your client, I guess, from their own accounts. But can you explain to me why your client, it appears, never sought payment throughout the time that it was doing work over the, I guess, many months that it was doing work without seeking some sort of progress payments?
I don't know, Your Honor, as to why. I don't know the facts as to that, other than what's been alleged is that they had assurances that they would be paid, and it was only after Vertelis declared bankruptcy and those funds weren't available from Vertelis that they sought them from the Superfund and from the site-specific funds.
Okay. All right, go ahead.
This is Judge King. Did you all, this started in 2012?
That's right, Your Honor.
Bankruptcy was like 5 years later. Did you all
Yes.
do work over the 5 year period leading up to that?
Your Honor, yes, there was work performed from 2012 to 2016.
Trying to clean up that mess there at Fairmont.
Exactly, Your Honor.
And you didn't get paid along the way from anything?
I believe it's my understanding that there may have been payment for portions of the work that were done before Vertelis, but at the end, ultimately, there was an outstanding balance of around $2.7 million.
Understand, and so that's one clarification. You're suing for an outstanding balance. How much have you been paid along the way?
I don't know that fact off the top of my head, Your Honor, but I could look for it and provide it to you in reply.
Is any of this information that Judge Diaz and I have been asking about in the record in this case?
I'm not aware, Your Honor, but I can double check that on the break.
Well, is there no administrative record that was created by the EPA in connection with this claim? Usually, when we have an agency decision and there's an agency appeal, the agency is obliged to file the administrative record. And that's what comes up on the agency appeal, and that we resolve the matter on. And I can't find any information in there. Now, you all, both sides, talk about the facts that indicate that you advised the EPA of what you were going to do, and they approved it along the way. And the EPA admits that, I believe, in their brief, that they were advised and they approved, but you didn't file this form that you say is expired in 1994. But what's the difference between approval and authorization? Do you know? You look it up in the dictionary anywhere?
I don't know that there's much of a difference in terms of the definition of approval and authorization, Your Honor. To us, it's a distinction without a difference. And I think that the court's point with regard to there not really being a record developed in the underlying case really highlights the fact that this case arrives to the court from a 12b6 perspective, and all facts alleged by August.
Well, how do you get into a 12b6 perspective when you got an appeal from an agency? I know that you have here. You filed papers with the EPA, and they put a three-judge panel together, just like you have today. They put a three-judge administrative law panel together, and that panel threw your case out. And then you filed a notice of appeal in the district court for Northern West Virginia, right?
Yes, Your Honor. I don't know that it was a three-judge panel in front of the AL. I believe it was just an administrative law judge, but yes.
Oh, I thought I read something about a three-judge panel. All right, administrative law judge. Administrative law judge made a decision, and you filed a notice of appeal. And then for some reason there was a complaint filed, and then an amended complaint, and then a second amended complaint, and then a Rule 12b6. It's almost like things got mixed up. It came up on an administrative appeal, and then it got into a regular complaint, the Rule 12b6, and it was disposed of, just as you said, as a dismissal under Rule 12b6. I'm sort of confused about the procedure, and nobody explains that. Either side, as I can tell, explains it in the brief. Maybe you all can explain it here. And of course, the EPA lawyer's listening in, and he's going to get a good chance to figure it all out here before we get around to it. But go right ahead.
Well, Your Honor, and with regard to that point, and in terms of what was decided in front of the ALJ at the EPA administrative level, it was also decided at a 12b6 on a 12b6 motion in terms of its equivalence. So ultimately, our request for relief in this case is the case be remanded back to the ALJ and the EPA to determine the case on the merits as opposed to deciding on it on 12b6 motion, which had to do with the form that was expired and obsolete and a violation of the Paperwork Reduction Act. Specifically with regard to the Paperwork Reduction Act in 44 U.S.C. Section 3507, the PRA states that an agency shall not conduct or sponsor the collection of information unless the agency has, among other things, submitted to the director the proposed collection of information and published a notice in the Federal Register. Additionally, the director has to approve the proposed collection of information, and the agency has to obtain from the director a control number to be displayed upon the collection of information. Importantly, that approval is not perpetual. Instead,
Mrs. Gallagher, can I interrupt with a question? So you're looking to remand to the EPA and ALJ to have discovery there, because you mentioned that you're looking for discovery. My question was, where would the discovery take place, and what discovery are you trying to obtain?
Well, in terms of the discovery that we believe would be important in this case, it would be with regard to the work that was performed. It would be providing information, to show the work that was performed in terms and getting the cost approvals. It would also be looking at the pre-authorization work that was ordinarily required by the EPA. The EPA's indicate in this case that they require it, but we believe that that sort of information is not ordinarily required by the EPA. Importantly, the approval under the Paperwork Reduction Act is not perpetual. Instead, the OMB director may not approve a collection of information for a period in excess of 3 years. That's 44 U.S.C. Section 3507, subsection G. So the EPA is required to seek renewal every 3 years for a form or collection of information. And the EPA pre-authorization regulations are directly subject to the PRA. In fact, when the proposed rule for the pre-authorization regulations were published in the Federal Register in September of 1989, a specific section was devoted to the Paperwork Reduction Act. However, the last time the OMB declared the form 2075-3 through OMB number 2050-106 was on June 4th, 1998, and that clearance expired on April 30th of 2001. Now, the EPA, in its response brief, has not identified any evidence or legal support to show that it renewed OMB number 2050-106 after it expired in 2001. So it's unrebutted.
Excuse me, Judge Diaz here. With regard to this argument regarding the Paperwork Reduction Act and the necessity for reform, there's no dispute, is there, that the statute certainly requires pre-authorization in some form. Whether or not this form was the appropriate way in which to do it, I think the statute is pretty clear that it requires pre-authorization. There's nothing in the record, as best I can tell, that your client made any effort to seek pre-authorization beforehand. It's now sort of making an argument after the fact, given the lack of payment that we talked about earlier from the primary source. So why wouldn't it have been incumbent upon your client to seek advice, a recommendation, or some input from the EPA as to how to comply with that statute, irrespective of the fact that the particular form may have expired?
Well, great question, Your Honor, and I would draw the court's attention to the statute itself, 42 U.S.C. Section 9611. There is in the statute itself, there is nothing in the statute that requires that authorization be provided prior to doing the work. There's nothing in the statute that speaks about pre-authorization. Instead, the statute itself states that such costs must be approved under said plan and certified by the responsible federal official. So the statute itself doesn't require pre-authorization. It's the regulation that requires pre-authorization. And our position in this case is that ultimately it was impossible for them to strictly comply with getting pre-authorization per the form, because the first step in that process was submitting a form that was expired and obsolete. And so they were unable.
So thank you for making that distinction. So the regulation imposed an additional requirement or a supplementary requirement beyond the text of the statute. So even in that context, why wouldn't it have been the proper response to have reached out to the EPA or some government official and say, hey, we've got this regulation and we're attempting to comply with it. There's a form that's outdated. What do we do?
Well, as I think, Your Honor, as the judge, you pointed out at the outset, that originally the intent was not to seek it from the Superfund. After Vertelis went bankrupt, then at that point in time, authorization was sought from the Superfund. So there was not an original intent to seek it from the Superfund. However, there was substantial compliance at the same time, because every single piece of work that was done by August Mack, as alleged in the complaint, was provided to the EPA, and the EPA supervised and authorized that work before it was done. So in terms of a substantial compliance standard, which is what we're advocating in this case, that information was provided to the EPA. And would draw the court's attention to the four purposes of
now,
the
you said it was authorized by the EPA before it was done the work. Now, and they're arguing that you didn't get it authorized by using this form. Is that the whole lawsuit here?
I think so, Your Honor.
They had to use this form. You had to use this form rather than a approval other than the form.
That's right, Your Honor.
And both sides agree that the work was approved before it was done by EPA.
Yes.
Is that right?
That's right, Your Honor.
Is that clear from the record?
I believe that it's clear from the record, Your Honor, and for purposes of this being a case that's on a 12b6, what we've alleged in paragraph 10 of our complaint is that the work was supervised and it was authorized by the EPA. And so, do you use the term authorized or approved? I believe we use the word authorized, Your Honor.
Okay. So we have to accept that as true if the civil rules apply.
Yes, Your Honor.
This is Judge Gallagher. I'm looking at paragraph 10, and it says EPA specifically approved AME as the supervising contractor and supervised all of the work AME performed and all of the costs AME incurred. Is there a difference between supervising the costs AME incurred and pre-authorizing those costs? It's unclear to me whether the process involved a real evaluation of the costs or was more focused on the work that was going to be done for cleanup.
Well, Your Honor, I think with regard to that allegation, it's such that all reasonable inferences must be taken in favor of August Mack, and so that would include both supervision and approval for that work.
But you aren't saying that you want your 2.6 million or whatever it is to the penny now. You just want us to send it back, and they can contest the exact amount, right?
That's exactly right, Your Honor.
Under your position, I'm summing up your position. I think trying to advance things along here because you're getting down close to running out of time, probably.
Yes, Your Honor, and that is ultimately the request that we're seeking here is a ruling as to the merits, because ultimately the work that was performed by August Mack on this site met all the requirements in terms of it being necessary and appropriate for that work to have been performed. In fact, the EPA is relying upon the work that was done by August Mack. And so ultimately what we're asking for in remand is that work be assessed on its merits as opposed to its failure to provide this pre-authorization form prior to doing the work. And ultimately, with regard to the penalty provision in the Paperwork Reduction Act, it states that no person shall be subject to any penalty for failing to provide with a collection of information. And the term penalty includes not only the imposition of a fine or other punishment, it also includes the denial of a license, privilege, right, grant, or benefit. And the plain meaning of denial is where there's a refusal or rejection, such as for a request or a petition, and a benefit. Certainly the benefit here to August Mack would be that $2.6 million that they sought in terms of the work that they had done and that was not compensated. And so I see that I'm out of time, Your Honor. We respectfully request that this case and that the district court decision be reversed and that this case be remanded back to the EPA to allow for a merits-based ruling by the EPA. Thank you.
Well, we really couldn't remand it to the EPA because we'd have to remand it to the district court and ask the district court to send it to the EPA. Be another step in there, I think, but we understand what you're trying to get.
Yes, thank you, Your Honor.
Reserved as well.
Yes, thank you.
Very good, thank you. Now, Ms. Schubert-Schmidt, you're here for the Environmental Protection Agency.
That's correct, Your Honor.
Good to have you with us, and you go right ahead.
Thank you. Good morning, Your Honors, and may it please the Court. Caitlin Schubert-Schmidt on behalf of the Environmental Protection Agency. At the outset, I'd like to note that the core of today's dispute is that Vertellus failed to pay its bills on a private contract, And while Vertellis's insolvency is deeply unfortunate for both August Mack and for the Environmental Protection Agency, August Mack's recourse was in bankruptcy proceedings. The fact that that process was unable to make August Mack whole does not mean that the federal taxpayer now can or should pay the bill. The district court correctly held that AME did not comply with the clear pre-authorization requirement and is thus ineligible for reimbursement from the Superfund. Further, the consent decree itself makes clear that AME is not entitled to payment from funds allocated under it. Because the district court properly rejected AME's claims, we ask this court to affirm. And at the outset, I'd just like to respond.
This is Judge Diaz. You mentioned, you started your argument off by saying that it would be inappropriate and inequitable for the taxpayer to foot the bill. What troubles me about this case, and maybe the record is deficient in the sense that there's no clear answer, is that wouldn't it also be inequitable and unfair and unjust for the government to reap a windfall at the expense of a contractor who did work for the government, whether directly or in this case indirectly, and was not paid? I mean, I can see if the government actually paid Vertellis and Vertellis, for whatever reason, didn't pay the contractor. Maybe that's what happened here, but the record just isn't clear. But if it in fact was the case that this contractor did work for the federal government, did work for the public, cleaned up the mess at this site, and ultimately was not paid, and because the government didn't pay Vertellis, that seems to be unfair and inequitable to me. So maybe you can talk about that to the extent that the record provides an answer.
Of course, Your Honor. I think that that's a great question because it highlights where the relationships here actually exist. And that's important because the relationship here was between Vertellis and a private business that it contracted with, August Mack. The relationship wasn't with the federal government and August Mack. And that's important because the purpose... I thought
you agreed, this is Judge King, I thought you all agreed in your brief that you did know what they were doing along the way for 5 years or 4 or 5 years there, and that you all approved the work along the way.
Yes, Your Honor, that's an important clarification. So after the consent decree was signed...
That's accurate, is it not? And that's what's alleged in the complaint as well. But you agree with that in your brief. So the EPA approved the work that this outfit did along the way, and they, I guess Vertellis paid them along the way to a certain extent, but they're suing basically or trying to recover the balance due.
That's right. So under the consent decree,
something in law school they talked about quantum merit or something. If you did some work, you're entitled to get paid for it by somebody, and otherwise there's a windfall to somebody. So here the EPA reaps a windfall, and of course the citizens of West Virginia, particularly Fairmont, reap a windfall because you do get this place cleaned up. And it was a mess and it was poison. It should have been cleaned up. But if this outfit did the work, it's worth something. Maybe it's not worth $2.6 million. Maybe it's worth $1.6 million. But somebody ought to be paying them for it. It seems to me as a matter of equity, and you were the one who brought up equity.
Well, Your Honor, the issue here is that both August Mack and the EPA were ultimately put in a really bad position by Vertellis' decision to go bankrupt, because Vertellis is the polluting party here. It's the party that bears the responsibility for the cleanup.
We know that Vertellis went bankrupt, and that's what precipitated this suit. But is it true that the agency has the discretion to compensate this outfit, August Mack, from the Superfund?
No, Your Honor, it does not, because August Mack did not comply with the regulatory requirement of pre-authorization. And if a party does not comply...
You're talking about from a legal standpoint. I'm asking you, does the EPA have the discretion, the agency have the discretion to compensate this August Mack for work performed on this site?
Under the regulations, no, it does not. It does not have that discretion, because it only has discretion to compensate parties if they've received pre-authorization to get reimbursement from the Superfund, or if the consent...
And you argue that they have to strictly comply with the use of this form, which is outdated. That would be, what if we agree with them, if they couldn't comply with that, use that form because it's outdated, it would be impossible to comply. Then you fall back to whether there's a strict compliance or a substantial compliance doctrine that they might be able to fall back on. You don't believe in a substantial compliance doctrine, correct?
Well, under the Paperwork Reduction Act, Your Honor, if a form is outdated, then a party is not obligated to use that form. But what the PRA specifically provides is that the agency has to allow a party to then prove or satisfy the relevant legal condition in any other reasonable manner. So the function of the PRA is in the manner of an affirmative defense. If the EPA sought to impose a fine or some sort of criminal penalty on AME, then AME in those enforcement proceedings could say, but you requested this information on an invalid form, and thus you can't move forward with those enforcement proceedings. But here, when August MAC is affirmatively seeking something from the government, what the PRA says is if the form is invalid, then AME is entitled to comply with the requirement in any other reasonable way. But it still has to comply with the requirement. And the requirement here is to seek pre-authorization. And that's what the clear definition under...
Now, they say that they did comply, substantially comply, because they presented their proposals to you all before the work was done, and EPA approved the work. And I thought both sides agreed to that, and certainly the complaint alleges that.
Your Honor, let me clarify, if I may.
This is hard for me to understand.
Of course, let me...
You have to find some way to comply, and you admit that they did comply.
We don't admit that they did comply because they didn't. And if I can take a moment to just clarify that.
You say in your brief that you approved the work before it was done. And you admit that we have to take the facts of the complaint as true.
It is correct that as AME was doing work on Vertelis' behalf pursuant to the consent decree, it submitted that work to EPA to show that Vertelis was complying with the requirements of the consent decree. Nobody disputes that.
Well, the work was done on
what
the
is at
issue behalf as well. In that,
right, but under the CERCLA doctrine, the parties...
And you represent the public interest. The EPA represents the public interest. It was in the public interest, the people of West Virginia and the United States, to get this place cleaned up. And I don't know whether it's cleaned up fully yet, but it's cleaned up some.
It's actually not cleaned up fully, and to the degree that EPA now bears the burden because of Vertelis' bankruptcy of cleaning up, EPA expects to not only exhaust the remaining funding available for cleanup of the site, but to have significant liabilities beyond the funding still left in the site-specific fund. So when there's discussion here of the equities and August MAC being left, sort of holding the bag, the problem is that EPA has also been left in a very difficult position of being responsible now for not only conducting the vast bulk of the site cleanup work, but also of funding all of that work. And so we're in a situation now where the polluting party, the party that's responsible for creating this mess, has essentially slipped away and not paid its bills to its private business that it contracted with. And if I can just clarify on the approval versus pre-authorization thing, the crucial thing that's absent here from AME's discussion of getting pre-approved or submitting information to EPA is that a crucial aspect of the pre-authorization process is that EPA has a chance to evaluate costs. It can evaluate whether or not a project is not just a high enough priority to be worth Superfund dollars at that particular moment, because there are so many sites and so many limited funds, but also to evaluate whether or not the project is going to spend the right amount of money, whether or not there's going to be financial oversight procedures in place, what the timeline is. And AME even admits in its reply brief at page 4 that it stands ready to submit cost information to EPA, which makes very clear that at the outset, AME was not providing that information to EPA before it was undertaking any response action, which is a crucial aspect of the pre-authorization process. It's not just that it's going to do X amount of work, it's that it's going to do X amount of work, it's going to cost Y amount, and this is how we're going to make sure that the money is spent appropriately. And that's really important because EPA has so many competing demands on the Superfund and on its workforce and availability to do site cleanup. So if these pre-authorizations aren't conducted in advance, then not only can EPA not decide between these varying projects of importance, but it also then can't assure private parties that funding will be available to pay them when they do work on EPA's behalf. So for both those reasons, it's incredibly important that this pre-authorization occur before work begins so that everybody is on the same page about what work will be done, how much it will cost, and who will get paid for it.
So you say I'm sorry, go ahead.
Oh, I was just going to follow up on that. Don't we not have a particularly clear record in terms of what information was or was not provided by AME to the agency at this point? Perhaps because there was no discovery, but the fact that we're trying to glean meaning from references and briefs rather than having it in the record seems to indicate that we don't have a very clear record about what the EPA might have had.
Your Honor, I would say that AME doesn't even assert that it provided this information to EPA in its complaint or later in its briefings, but also that even if there was some discovery that showed that there was some cost information provided or there was, certain other approvals that were made, that wouldn't change the fundamental fact that August MAC did not even attempt to get pre-authorization for its claims because it was never intending to be paid by EPA. It had made a private contract with this polluting party, Vertelis, to do certain work for Vertelis. So there simply wouldn't be anything revealed in discovery that could change that basic fact. And I'd also like to take a moment here, if I can, to focus on the fact that when August MAC is making this argument that it substantially complied with the pre-authorization requirements, it's not pointing to anything in the actual language of the regulation, the language of the statute, or in the case law or other court doctrine that would allow this sort of substantial compliance doctrine to apply to this otherwise bright line rule. I mean, the regulations clearly state that a claim must be pre-authorized. Even if there's some flaw in the application process that's later delineated, that wouldn't change this baseline feature that claims must be approved before they're authorized for reimbursement.
Well, I thought that if you agree they were approved, do you think there's some material difference between your approval and the authorization form?
Yes, and part of that is because if you look at the regulations in 307.22 and 307.23, it talks about the sort of broad swath of data and information that's required in order to pre-authorize a claim. And that process means that an application has to be submitted in advance. EPA has to have an opportunity to review that application, to analyze it, to compare it with other priorities. And then EPA releases what's called a pre-authorization decision document. And that document clearly articulates for the benefit of all parties what particular work is authorized and then what the actual reimbursement will end up being. And far be it from AME's assertion that this process isn't used, but you can see in the record here, I think it's on page 283 of the Joint Appendix, a clear example of one of those pre-authorization decision documents that clearly references that an application was submitted. EPA reviewed that application pursuant to the regulations, and it sets forth all of the criteria for that party to seek reimbursement. And we've provided additional examples in our brief. Yes, this process is used infrequently, but it should be used infrequently because the point of it is to supplement times when polluting parties cannot be found to finance their own site cleanups. Otherwise, we shouldn't be using the Superfund as some sort of super insurer to make up for when polluting parties don't pay their own bills. That's not the function of the Superfund. It's to clean up hazardous waste contamination when there's no other possible way of doing it. And that's why the regulations were written the way that they were. And AME also seems to make this...
Yes, sorry. If Vertelis had not filed for bankruptcy in this case, can you describe to me from EPA's perspective how a contractor like August MAC would have been paid? It sounded like you said this is a private contract and they would have looked directly to Vertelis. But there's also information in the record that suggests that if Vertelis failed to complete the work, then EPA would be authorized to then take over the work and use whatever remaining funds were available from this cleanup fund that was created to cover the costs. And wouldn't that include the costs that a contractor like August MAC, the work that it would have done on this site? So ultimately, wouldn't it, it's not clear to me from the record exactly what happened, but wouldn't EPA have then been obligated to pay August MAC from the funds that were provided by the other polluting defendants in this case?
No, Your Honor. And the reason for that, first of all, is that the consent decree and the way that this was set up never contemplated using any money from the Superfund. Right? The obligation was that Vertelis was the performing defendant. It was responsible for completing the cleanup work, and it was responsible on its own for paying contractors to complete that cleanup work if it didn't want to do it in-house. That's the penalty you get for being a polluting party. The consent decree site-specific funding is a little bit trickier because the way that functioned was essentially an insurance policy for EPA. If Vertelis did something like went bankrupt or just threw up its hands and said, well, we just don't want to work on this anymore, we're not going to fulfill our obligations, then suddenly, because the goal is to clean up the hazardous waste site, EPA has to step in and take over those responsibilities on its own. And so that money exists within the consent decree site-specific fund to ensure that there's some ability for EPA to continue that work. And as I've mentioned before, EPA already expects the liabilities of the site to exceed and likely in the future greatly exceed that pot of money that's available. And this is not related to the Superfund claim.
So would not have that responsibility would not have included paying those contractors who had done work but have not been paid?
Well, no, Your Honor, and that's because the recourse for a private party that's made a contract with a party that's then gone bankrupt is a claim in bankruptcy court. It's up to the bankruptcy court to evaluate all of Vertelis' outstanding liabilities and determine where the money that was remaining, was appropriately returned. And it's certainly unfortunate that neither EPA or AME was able to be made whole by those bankruptcy proceedings in terms of its obligations and outstanding financial responsibilities, but that was the recourse that August Mack had when Vertelis chose to go bankrupt.
Let me take you back to the question I asked at the very beginning of your argument, because I think you may have answered it, at least indirectly, but I want a direct answer from you. Do you think that the public and or EPA has received a windfall as a result of this contractor not being paid and having performed work on this site? And if not, can you explain why?
No, Your Honor, because there was a company here that had contracted to have work done. That work was Vertelis' responsibility to get done. It instead of doing it in-house, it paid another party to do that work for it. It elected to go bankrupt and it elected not to pay its bills. If the work was done and the contractor wasn't paid, how is that not a windfall to the public and or EPA? Because EPA still has many outstanding liabilities that it has to move forward with on this site. And the reality is, even if EPA did want to take some action to compensate AME for the work that it had done in the past on the site, there's simply no mechanism within the regulations or under the consent decree that would allow EPA to do that. And we wouldn't really want that anyway.
That's a different issue, and you've argued that I think here today. But when you talk about the fact that there are other liabilities that exist on this site, those are issues independent of whether or not this particular contractor did what it had been retained to do. And it sounds like they did. I mean, at least from the records we understand it. And the government's response here seems to be, well, it's unfortunate, but them's are the rules. Bankruptcy is the only option. There is no mechanism as a matter of equity for the government to pay this contractor, even if it felt it was appropriate. Is that correct? Is that your position?
Yes, Your Honor, and I'd urge you to think through what the logical conclusion of AMU's assertion here is. If that was a mechanism that was appropriate, then there would never be any benefit to a polluting party to pay its own contractors, because why would it when it could just not pay them? The contractors could do the work. It might be work that was not appropriate for a site or not a particularly good use of money, and then that contractor could just say, well, I didn't get paid, so it's up to EPA to make up the difference. And that's simply not how CERCLA was designed or what the goals of CERCLA was, which was to get hazardous sites cleaned up and paid for by the polluting parties that were responsible. And so establishing that kind of system would just not be tenable for either the limited amount of money available in the Superfund or to meet the goal of actually ensuring that hazardous sites were cleaned up effectively and efficiently and cost effectively. So
Yeah, so the paperwork reduction claim and the issue of the penalty, I mean, you do concede that this form has aged a bit, and there doesn't appear to have been any effort on the part of the government to try to update it. But I think you also mentioned in your brief, or maybe it's in the record, that the government continues to rely on the pre-authorization requirement, and in fact, there are methods by which a contractor can comply with that requirement short of having to rely on the form. Is that right?
That's correct. And I would also note that, if I may, that a contractor like AME is not the particular type of party that you'd usually see seeking pre-authorization. The context in which pre-authorization usually occurs is when there is some sort of mixed funding consent decree. And what I mean by that is you have a responsible party, a polluting party, who's agreed that it's responsible, that's willing to take on the work to clean up a site, that can pay most but not all of the bills. And EPA then says, okay, well, it would be a really good use of Superfund money to say, if we can make us that little bit of difference financially, this party is going to move forward and clean up this entire site. And that's the context in which it's usually used. And that's why you usually see these pre-authorization decision documents within the context of these mixed funding decrees. And I hear that my time has expired. Simply say, AME did not receive pre-authorization. That is a requirement of the regulations, and there's no discretion around that, and we ask that the district court's dismissal be affirmed.
Judge Gallagher, you got any further questions?
No, thank you.
Judge Diaz?
I do not. Thank you, Judge King.
Thank you, Ms. Smith. We'll turn back to Mr. Zimmerly, and he's saved for rebuttal time.
Thank you, Judge. The government in this case is not contending that they did not authorize the work. They were simply taking the position that it was not pre-authorized. But that entire process starts with an expired form, and relying upon that form violates the Paperwork Reduction Act. And August Mac can't incur a penalty for failing to submit that form under 44 U.S.C. Section 3512. The regulation that opposing counsel referenced with regard to looking to whether or not that information was provided in any other reasonable manner is actually from the regulation, not from the statute provided by the Paperwork Reduction Act. And to the extent that this court would look to that regulation, that in any other reasonable manner is looking to substantial compliance. And ultimately, August Mac substantially complied in that the costs that they incurred were all approved and authorized by the EPA before that work was done. Ultimately, the agency did get a windfall from the bankruptcy. They received $37 million in site-specific funding that was supplied to it as a result of that bankruptcy. And all of the arguments about future losses only mean that windfall might offset future costs, but it's still a windfall. With regard to discovery, Judge Gallagher asked about that, and I wanted to provide further clarification as to the discovery that we would seek in this case. We believe that getting to the supervision of the work, that's why we need discovery, to answer the questions of whether they actually authorized to incur those costs. We believe that those costs were authorized, and we believe that discovery would bear that out. August Mac absolutely was submitting those costs to the EPA, and we stood ready to submit that info to the court so it could review it. All of our scopes of work that the EPA reviewed and approved included cost information. Not detailed breakouts, but budgetary costs were provided for each task. And evidence of those future costs, evidence of future costs is not in the record. That's another area of discovery. So ultimately, Your Honor, we believe that for purposes...
Mr. Zimmerly, you're saying that substantial compliance is the rule, and since they said strict compliance is the rule, it was a legal error. Is that correct?
Yes, Your Honor.
You're not asking us to say that you did substantially comply. That would be something where if you get discovery or get a remand, that would be reserved for that procedure, right?
That's exactly right, Your Honor. We believe that strict compliance cannot be required in this case because of the Paperwork Reduction Act, because the form was obsolete and expired. And so the court should look to substantial compliance, and the EPA should look to that standard, and ultimately we met that standard.
But you aren't asking us to decide substantial compliance today. You're asking us to send it back.
Yes, Your Honor. For these reasons, Your Honor...
I interrupted you. If you need to finish your thought there.
Those were my final thoughts. One other piece of information that Judge Diaz had asked about at the beginning was the amount of money that Vertelis had paid to August Mac. That amount is not in the record that I could find. It's my understanding that there was not a great amount of money other than the $2.6 million that was owed that August Mac performed. I believe there was some amount of money that paid, but that it was not great.
There were other contractors in there working on cleaning up this place besides August Mac?
I don't know that that's in the record either, Your Honor.
Well, right, but You think the discovery would reveal all that, I guess.
It certainly would, Your Honor. In any event, I'm out of time, but if there are any other questions, I could certainly take them, Your Honor.
Anything further, Judge Gallagher, Judge Diaz?
No, thank you.
No, thank you.
We appreciate the arguments of counsel. Your appeal will be taken under advisement. Thank you very much. It is good to be with you today.
Thank you very much.
Madam Clerk, now do we
Thank
go
you.
off this call? What
Yes,
happened?
sir. I will end this call and call you all back for the next argument.
Thank you very much.
The court will take a brief break before hearing the next case. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Our next case this morning is number 19.
The Judges of the United States Court of Appeals for the Fourth Circuit.
Our second case this morning is number 19-2075, Carmack versus the Commonwealth of Virginia. Mr. Grimes, are you there?
Yes, sir.
Pleased to have you with us, sir. You may proceed.
Thank you. May it please the court, this is an appeal of a summary judgment order from the Western District of Virginia in a case brought under the Virginia Whistleblower Protection Act. This case should have gone to the jury for the following reasons. First, look at the termination letter, which is dated January 4, 2018, and is in the joint appendix at page 18. Matlock said there that Carmack's position was abolished due to budgetary reductions or shortfall. But if you look at the defendant's answer, which is in the joint appendix at page 115, paragraph 37, the defendants admitted that there was no budget shortfall at the time Carmack's employment was terminated as claimed by Matlock. In fact, there was an excess of $700,000 in general fund revenue, which had been earmarked to cover staff salaries in the event of an unexpected budget reduction. For that reason alone, this case should have gone to the jury with respect to the question of causation.
Your line is now muted.
By Matlock in writing to justify abolishing the position was false. Moreover, the position abolished was that of chief financial officer. Think about that for just a moment. This agency could have no more gotten rid of the chief financial officer than this court could get rid of the clerk of court. You can't survive without those positions. And that's exactly what one of the board members said and told Matlock, look, you have a claim for retaliatory discharge. We can't get rid of the chief financial officer. What Matlock did instead was to terminate Duffy Carmack because he was a whistleblower. Over time, and this is all set forth in great detail in our reply brief, Matlock engaged in oppositional activity that ripened into participation activity, which culminated with the termination of his employment. This is a classic whistleblower case, just like DeMasters versus Carillion, decided by this court, 796 F3rd at 1109. And Judge King, just like Saunders versus Metropolitan Management, a panel that you sat on and I argued, and this is an unpublished decision, 2020 U.S. Lexus at 8565. The animus was personal, and Matlock spoke in terms of, quote, pulling the trigger, close quote, on Duffy Carmack and no one else. So we have two possible... Yes.
Sorry, Judge Diaz here. Let me take a step back for a moment and ask you to tell me, you've made an argument with respect to proximate cause. It's, having read your brief, you seem to spend most of your time complaining about whether or not an affidavit filed in a reply brief down below was appropriate, and whether or not the district court made a mistake in, instead of applying state law principles of proximate causation, applying the McDonnell-Douglas test to this state retaliation claim. But I couldn't find anywhere in the record where you, or for that matter, the other side objected to the district court judge applying McDonnell-Douglas. So haven't you waived any argument with respect to proximate cause on appeal?
No, Judge Diaz, for this reason. At the beginning of the case on motion to dismiss, the district court stated that under Erie, it was going to apply ordinary state law concepts of causation with respect to the whistleblower claim. So that's the way we prepared the case for months going forward, took all the depositions, conducted all the discovery. Then we got the opinion from the district court in August of 2019. The district court changed horses midstream and said that it was going to apply McDonnell-Douglas, but for causation and so forth. that left us 30 days to note an appeal. So I've never had a case like this where the judge announces at the beginning of the case that the law is going to be one way, and on summary judgment, when the judge writes the opinion, he says that it's something else altogether. So no, there's no waiver there from our perspective, Judge Diaz, for that reason.
Was there a hearing?
A summary judgment hearing? There are many hearings.
Right.
Yes,
So,
there were. Yes, there were.
Did at some point, Judge Urbanski, I think, was a judge here, did he at some point sort of reveal his hand that he was in fact going to be applying McDonnell Douglas, and did you object at any point along the way?
The judge did mention McDonnell Douglas at the hearing. That was in May of 2019, but it almost seemed to be in passing. And remember, we already had the judge telling us early on that he was going to use state common law. Yes, he mentioned McDonnell Douglas, but he didn't say, and this is the law I'm going to apply to the facts of this case. It wasn't until we got the written opinion 3 months later in August where the judge talked for 30 pages about McDonnell Douglas. So yes, that's the answer to your question.
Mr. Grimes, this is Judge King.
Yes, Judge King.
At page 39 of the judge's opinion, footnote 23, the court says neither party explicitly analyzes counts 1 or 2 under the McDonnell-Douglas framework in their briefs. Nevertheless, it is clear that both parties assume this proof scheme applies. So did you ever complain to the trial judge about that footnote?
No, the footnote was in the summary judgment order. And look, the judge notes specifically, neither party argued McDonnell Douglas. Why is that? Because the judge told us all along that he was going to decide the case under state law concepts of causation as required by He said it was clear to him that both sides assume that was the proof scheme that applied. That's what he said right there in that footnote 23. Yeah. I have it right before. Why would that be clear to the judge when he told us one thing at the beginning of the case and this doesn't come out until the end of the case? I don't know why it'd be clear that the parties agreed to that or argued that when he in the first sentence says neither party argued McDonnell Douglas. So I mean that's one of the issues in this case. One of the issues in the case, the judge changed the law, if you will, in the middle of the case. In our view, that's merely one issue in this case. But look, even if
you also you certified to the Supreme Court of Virginia, right?
We did.
That has to do with this issue.
It does. And that argument is very simple. I'm not going to dwell on that. The argument is there, and I brought it up largely because of something that Judge Traxler said in another case, that in a case of first impression, which this is, look, there's no case law, state or federal, deciding cases under the Virginia Whistleblower Protection Act. In our view, Virginia ought to have the first shot at construing what level of causation it's going to apply. And I've cited on brief, and I could go over it, there are cases in Virginia that say the Supreme Court of Virginia rejects McDonnell Douglas.
Why didn't you make that motion to certify to Judge Urbanski before he wrote his 75-page opinion?
I don't know how we would have known to do that because the judge told us to bring it up.
Why wouldn't you bring it up?
The only way we would have brought it up would have been post-summary judgment order when the case is over. In our view, we have 30 days to note an appeal. But you're right. We could have, in that 30-day window, filed a motion to certify, a motion to stay the judgment, and then ask the district court to certify the case. I guess we could have done that, but we didn't. And even if we're faulted for that, at any causation level you want to apply, but for plus, proximate cause, causation, whether but for is the sole cause for an action. Look, at some point, all that gets to be how many angels are dancing on the head of a pin, but any level of causation, this case could have gone to the jury because you have two reasons for discharge out there. Possible because Carmack was a whistleblower, and possibly because of some budget issue. That case goes to a jury every single time because what Judge Urbanski did is weighed the evidence and found in favor of the defendant and looked at the evidence in the light most favorable to the non-moving party in violation of Tolan versus Cotton. So in our view, choose whatever your standard that you want. The case should have gone to a jury. But our point is, Judge King, that we think the Supreme Court of Virginia ought to get the first shot. If you disagree with that, just decided under ordinary principles of causation or McDonnell Douglas, which we're not asking you to do. I'm not conceding or acquiescing anything there. We think we prevail under any standard of review with respect to the question of causation. For these reasons that I was about to tell you, if you just look at the timeline in this case, it's telling, and that's in our brief. And what happened was, in November of 2015, Carmack reminded Matlock that I'm going to follow state accounting policies and procedures. Matlock said immediately that he uses a needling technique to get rid of employees that he does not want. Now, that's oppositional activity at the very beginning of the case. Then in December of 2015, Brooks told Matlock that she planned to retire. Matlock moved Adam Tolbert, pre-selected Adam Tolbert for that position, and Carmack said, you can't do that. You can't pre-select people into the state system. Probably the same way under civil service in the federal system. Then in January of 2016, Carmack tried to meet with Matlock to discuss the budget process for the next year. Matlock said, no, I'm not talking with you. I'm going to talk with Chris Fields, who had not worked at the center for 4 years. She wasn't even an employee. Then in January 2016, Matlock started working on a process to find another volunteer to make the WTA look legitimate. Then in December of 2016, Carmack complained to Matlock about suspected fraud and abuse concerning overpayment to the Tates, Matlock's friends who worked in IT, who weren't actually doing any work for the center, but were getting paid, the two of them, over $100,000 a year. Then in December of 2016, Matlock told Carmack that I don't want the Tates to report to you, even though they're Carmack's employees. Then he didn't want Carmack to approve their timesheets, and that Carmack should back off all violating state policy and procedure. This goes on and on. Then Carmack, in February 2017, complains to the ombudsman at UVA. They have HR oversight for the center. The next morning, Carmack...
This is Judge Gallagher. Sorry, I want to interrupt with a question on a little bit of a different point. You mentioned that you were denied the opportunity to depose Mr. Mall, the true author of the memoranda. Where in the record did you ask to depose Mr. Mall, even during the period after the sanctions had been granted?
Yes, Judge Gallagher, we didn't file a motion. I don't want to tell you wrong about this. I think we asked to depose Mall and complained that we're not able to do so. And this is the Rule 37 issue. After discovery closed, there was a document dumped by the defense of 2,500 documents, including the Reagan memoranda from the governor's office. That's the August and September 2016 memoranda that talk about a 5% budget reduction to state agencies that are not institutes of higher learning. And so that's when we asked to depose Paul Reagan. The judge let us do that. And Reagan said, look, we're not aware in the governor's office that this 5% reduction would result in the loss of any personnel, much less the chief financial officer of the center. Then we also asked to depose Mall. And I can't tell you right now, Judge Gallagher, where that is in the record. But the judge said, no, I'm not letting you depose Mall. So but if that was one of the arguments on appeal, shouldn't it be in the record somewhere? I mean, I didn't see it anywhere in the record. I agree with you. It should be in the record somewhere, and I think that it is. The record's 2,500 pages, and on my break, I'll go back and try to find it, but I can't point it to you. I can't point you to it right now. But the point is, the defense did a document dump under Rule 37. There's no discretion with the district court. Rule 37 says when that occurs, the defense does not get to use those documents, does not get to use that Matlock affidavit or any of those 2,500 documents. The district court overlooked that and let them use it anyway. That became the linchpin by the defense, and that's why they didn't do it. They never gave it to us before. That became the linchpin for their argument concerning termination until we took Matlock's deposition, and he said that memorandum played a small part, a very small part in the decision to terminate Matlock, thus undercutting all efforts by the defense with respect to that document dump. And for all those reasons, we think the case should have gone to the jury. And for other reasons as well, DHRM did not approve the WTA plan until 6 months after Duffy Carmack was terminated. That was all a smokescreen. The other two employees, the women, Brooks and Williams, they planned for 2 years to retire, and that is in the record. And this wound up costing the state more money because it provided an enhanced retirement package to them. In addition, under this WTA plan, you're supposed to try to find another job for Carmack, and you're supposed to call him back after some period of time. We're going on 3 years. He's never been called back. I fall back on the pull the trigger language. What Matlock did is he said, I'm going to pull the trigger on Duffy Carmack. That's a telling metaphor. That's an execution within the employment context because he was a whistleblower. So that's for all these reasons. We think the case should have gone to a jury. I see that I'm running out of my time, so I'll stand down and await further questions. And I'll look for that question that you asked me, Judge Gallagher, while I'm standing down here.
Thank you, Mr. Grimes. You have some rebuttal time.
Yes, sir.
Mr. Hardy. Mr. Hardy, you with us?
Yes, Your Honor. May it please the court, my name is Ryan Hardy, and I'm here on behalf of the appellees, the Commonwealth of Virginia, the Southwest Virginia Higher Education Center, and David Matlock. This appeal involves two issues: the district court's application of the McDonnell-Douglas framework to dismiss Carmack's Virginia statutory wrongful discharge claim, and the district court's refusal to strike a second declaration by Michael Mall of the Department of Planning and Budget. And I was turning first to Mall's declaration because counsel made some major misrepresentations of the record. First of all, there was not a 2,500-page document dump that occurred after the close of discovery. The disclosure of those documents occurred prior to the close of discovery. Yes, 2 memorandum and approximately 10 other pages worth of documents were produced after the close of discovery. It was inadvertent, but the district court granted the plaintiff's discovery sanctions motion. And at no point did Carmack ask to depose individuals. He did not ask to depose Michael Mall. He did not ask to redepose other individuals. He just wanted to strike evidence completely. And in face of that, the district court split the baby in a sense and allowed him to depose people they had deposed previously and to allow the deposition of Paul Reagan. There was never a request to depose Paul Reagan. There was never a request to depose Michael Mall. And so what counsel is trying to do is turn this back to relitigating the sanctions motion. We're here to discuss the decision to not strike Michael Mall's declaration, and that is reviewed under the deferential abuse of discretion standard. This deference to the judgment is heightened in this case because there are few, if any, bright line rules governing the adequacy of initial disclosures. The 1993 Advisory Committee notes explain that Rule 26A1 simply requires a litigant to indicate briefly the general topics on which such persons have information. And that is where Carmack's issue and challenge fails because the district court has rejected each of the arguments that he makes now. The district court held that Mall's second declaration fell squarely within the subject matter contained in the Commonwealth's initial disclosure and subsequent discovery production. Mall was identified as an individual whom Matlock told that he would be submitting a Workforce Transition Act request later in the year, and that the CFO position was one of the positions planned for elimination. And the Commonwealth produced documents along with this initial disclosure that put Carmack on notice that Mall had relevant information. This included the request for approval from the Department of Planning and Budget for the reorganization proposal, and it specifically mentioned the budget reductions enacted in the Appropriations Act and explained that the layoffs were due to budgetary shortfalls in the Commonwealth for fiscal years 2017 and 2018. And this can be found on page 387 and in the joint appendix.
Mr. Hardy, Judge Diaz here. Excuse me. Your friend on the other side suggests, and you may be about to get to this, but I wanted to ask it now, that everybody was surprised by Judge Urbanski's use of the McDonnell-Douglas test in his summary judgment order. It appeared, at least he represents, that early on, Judge Urbanski indicated that Erie principles would apply, I guess the implication being that because McDonnell-Douglas is a matter of substantive law, and that's a question that I guess is not a slam dunk, that there's some question about that, but I guess the assumption is because McDonnell-Douglas that test is a matter of applying substantive law, that instead that the typical elements of proximate causation should apply in this case. Was the Commonwealth surprised by Judge Urbanski's use of McDonnell-Douglas in this case?
No, Your Honor, because we specifically invoked the legitimate business defense prong of the McDonnell-Douglas test. And we did not differentiate between the Whistleblower Act or the First Amendment. And then, and this is in docket number 64 at 21, I'm referring to the summary judgment pleadings. ECF number 64 at page 21, ECF number 72 on pages 10 through 13. And that is Carmack's opposition to summary judgment. Our reply brief at ECF number 74 at 11, the supplemental pleadings, ECF number 100 at page 1, and ECF number 102 at 4. Thus, the pleadings assumed exactly what Judge Urbanski said in that footnote, that the McDonnell-Douglas legitimate business reason analysis applied to both claims. And in fact, on page 1909, this is the transcript from the summary judgment hearing. Counsel for Carmack said, "Our first argument is based on the fact that there was no legitimate business interest need for the reduction." So Carmack himself invoked the McDonnell-Douglas analysis. And that is why, as the panel was questioning earlier, the issue is waived under either the forfeited error analysis under Alano or the invited error analysis. And invited error, that you only need to have a tacit agreement in order to be precluded from challenging a decision from the court. In Ridge v. Cessna Aircraft 117 F3D 126, the parties agreed that the jury could use the courtroom to deliberate, and there happened to be a model airplane that the counsel had used as a demonstrative exhibit. And a jury member happened to use it as during the deliberations and tendered a verdict for the plaintiff. The defendant appealed, claiming that it was error for the district court to allow that model airplane to be in the courtroom. But this court rejected that and said that the defendant knew the model had been left in the courtroom and should have objected when they had the chance. That is exactly what happened here. Every time that the Commonwealth cited legitimate business reason analysis, that should have put Carmack on notice that I need to make this Erie challenge. And When the district court held in the motion to dismiss stage, when he invoked Erie, that was only for the substantive components of the Whistleblower Act. He did not say that McDonnell-Douglas was a procedural or a substantive law, because as this court is aware, the Erie Doctrine says that when a federal court has pendant jurisdiction over a state claim, state substantive law is applied and federal procedural law is applied.
Mr. Hardy, can I ask, thank you for that response to my question, but let me talk about the record a little bit, because your colleague on the other side spends a lot of time talking about what Mr. Carmack had done while he was still engaged as CFO and pointing out various issues and deficiencies and what he alleges to have been unlawful activity by Matlock during the course of his work. And he says that all of that amounted to oppositional activity, which shows that this work reduction the work reduction decision made by you and not you directly, but by Mr. Matlock and the Commonwealth was all just a pretext for getting rid of someone who was engaged in oppositional activity. But as I understand it, the record in this case shows that the earliest date at which Matlock knew of Carmack's complaint as a whistleblower was in October of 2017. I think October the 16th of 2017. So can you explain to me how, if at all, we're to consider the oppositional activity as relevant to the question of pretext, given that date, that operative date in the record is the date on which Mr. Matlock actually knew of the whistleblower complaint?
Yes, Your Honor. The timeline is actually fatal to Carmack's claim as it relates to causation, because the first time that David Matlock notified another agency, the University of Virginia, of his intent to abolish Carmack's position was November 8, 2016. This can be found on page 157 of the appendix. And this, of course, predates the October 2017 date in which Carmack alleges Matlock learned about his complaint to the Office of State Inspector General. That 11-month gap is fatal as a matter of law.
But your friend on the other side says you can't just look at that in isolation. You need to look at all the, as he described it, characterized it, oppositional activity that Carmack was engaged in pointing out all these problems that were occurring in the workplace with respect to Matlock's, daily work activities, the allegedly unlawful activity that was taking place. So how are we supposed to consider that?
Well, those oppositional activities do not amount to actual protected activity under the Whistleblower Protected Act. The November 15th warning that Carmack intended to follow the rules, that's not actually highlighting an instance of fraud, waste, or abuse. That can be found on page 638 and 639. The concerns in December 2015 and January 2016 about pre-selecting Adam Tolbert, again, that occurred well before, 11 months before Matlock indicated his intent to, or at least looking at Carmack's position to be abolished. So that same temporal issue arises there. And that can be found on page 650, 651, and 1718 of the appendix. And then finally, there's the September 2016 concern about pre-selecting Joe Mitchell to be facility manager. That is more of a personnel issue and not a type of fraud, waste, or abuse. And the record demonstrates that Carmack knew that Mitchell had actually applied for that position on page 695 through 697. And finally, as a point of, I might have misunderstood counsel, but the reference to the overtime payments to an IT couple, there was some confusion about the timing of when Carmack made his complaint.
at the summary judgment motion, and he initially filed a declaration saying it occurred, he made the complaint December 2015. Then on summary judgment, he asked to be put under oath, and he was questioned by his counsel, and he said, no, what I meant was December 2016. So either way, the same temporal problem arises. It's either occurred way too early, 11 months before Matlock decided to look into abolishing Carmack's position, or it occurs after. So either way, it does not help Carmack. And
Mr. Hardy, let me ask you about this in the record and ask you to comment on it. As I understand the record, once Mr. Matlock received word of the need to make these reductions in budgets, that he and Carmack worked together and actually put together a budget that complied with the Commonwealth's requirements for a budget reduction without having to eliminate anybody from the workforce. For some reason, unexplained reason, in the record, maybe you can explain it. Maybe I just haven't found it. That budget was withdrawn, and then this new budget is put in place that actually requires a workforce reduction. You know, on the face of it, that seems a little bit squirrely, maybe suspicious. So what about that?
Absolutely, Your Honor, and it dovetails into the small parts issue that counsel mentioned earlier. So first, Matlock had received the August budget reduction memo that said we're having budget reductions for fiscal years 2017. Plans are due in early September, and that's when Carmack submitted that budget, and everything was fine. And then the second budget reduction memo came in on September 26, 2016, and that, as Matlock testified, that is what frightened him, because now they're having an additional year of a budget reduction and for fiscal year 2018. So he's not just looking at one budget reduction for one fiscal year, he's looking at for two, possibly more. So that's when he has to start looking into what can we do for this center, because he's identified that, you know, in order to remain viable, the marketing position that Carmack had proposed eliminating, that was needed. And so the timeline syncs up, because then he goes in, he starts crunching the numbers, and this is in November 2016 to February 2017. And in February, he goes to Michael Mall and asks him, I know that there was already a budget submitted, am I precluded from, you know, changing things up a bit? And Michael Mall said, no, the General Assembly did not specifically dictate how you were to apply the budget reductions. Therefore, it remains within your discretion. And so this is where the DeJarnette line of cases comes in, and this becomes the managerial prerogative. And so when Matlock received the second budget reduction memo, that's what changed his mind and created the need to look at other options. And he was able to create a budget reduction plan. It eliminated 3 positions, but in his view, it helped establish the position of the center to be more efficient and effective going forward. And to counsel's point that you can't survive without a CFO, the center is still alive. It's doing very well. It has managed to weather the pandemic and the further budget crunches quite well. So that alone is not enough to say that a CFO must be necessary. And the federal courts are not in a position to second guess those business decisions. And finally, I do want to point out, I was flipping through counsel's reply brief with this court, and on page 23, he does cite to Reeves, the Sanderson plumbing, and he cites other cases that use the pretext McDonnell-Douglas language. So that would seem like even still he believes that the pretext analysis applies. with equal force. And ultimately, when we're talking about causation, the issue here really is, did the court err in applying McDonnell Douglas? And if that issue is waived, either through forfeited error or invited error, then the causation component becomes unnecessary. And in fact, it is unnecessary to even look at this because McDonnell Douglas does apply here because it is the case law, even though the Fourth Circuit has not definitively ruled, there's enough there to say that it is a procedural law that should be applied in any state discrimination claim, unless there's some substantive component of the statute compels a different result. The McDonnell Douglas framework doesn't have any of the makings of a substantive law, as the Supreme Court has defined in Hannah v. Plumer. It does not change the ultimate burden of proof. That is something that this court has said multiple times, and Brinkley and Enos. And the Supreme Court itself has said that McDonnell Douglas is a procedural device designed only to establish an order of proof and production. That's St. Mary's Honor Center v. Hicks, 380 U.S. 460. So if the district court did not err in applying a procedural component of Rule 56. And so long as the legitimate business reason analysis applies, then Carmack's claim must fail on that point. And it's our argument that that challenge has been waived through invited error and forfeited error. And I finally want to have a couple other points on Michael Mall. This is a very differential standard of review. And as I mentioned earlier, there was not a 2,500-page document dump after the close of discovery. That occurred prior. Counsel is completing two different things. And I laid this all out in a declaration that I submitted to the district court that can be found on ECF number 75-1. And then the final. And finally,
I believe that was your bell. Oh. Go ahead and finish the thought.
And the document production in this case puts Carmack squarely on notice that a statewide budget reduction was the reason for the elimination of his position. So this concept that there was no budget shortfall within the center is a red herring, and the district court properly rejected it. And unless the court has any other questions, I thank you for your time, and Carmack has not presented any basis to reverse the district court's order. Thank you.
Judge Gallagher, you have anything further?
I do not.
Judge Diaz?
No, thank you, Judge King.
Thank you, Mr. Hardy. We appreciate it.
Thank
Mr. Grimes?
All right. First, with respect to counsel's argument that oppositional activity is not actionable under the Virginia Whistleblower Protection Act, I don't know where he gets that because it's certainly actionable according to Crawford versus Metropolitan Government of Nashville, the Supreme Court case, and this court's decision in DeMasters versus Carillion. And it's as common as rain for oppositional activity to precede participation activity. Turning to your question, Judge Gallagher, I did find an answer for you. I think the answer is in the negative. We did file a motion to strike the defense declaration of Mall, and that's in the record below at document 103, and our reply brief at document 105. Also, our reply brief to the motion for sanctions at document 76, but we answer your question in the negative. But how would we know that Mall ghost wrote the Reagan memoranda until we took the deposition of Paul Reagan? So we had no need to depose Mall until we learned that he ghost wrote the Reagan memoranda when we took his post-summary judgment deposition. So in conclusion, we're left with the fact that Matlock just said, I'm going to pull the trigger on Duffy Carmack and no one else. And he said he'd never said that with respect to any other employee. That's evidence of personal animus. Judge Diaz, your point, I think, is well taken. With respect to the budget issue, Carmack, as the CFO, he solved the budget problem without the loss of any employees. And then Matlock turned it around and said, no, I'm going to work up another budget that gets rid of you, Duffy Carmack. That's personal animus. It ought to be actionable under Virginia Code Section 2.2-3011, which is the Virginia Whistleblower Protection Act. I'll answer any questions that you may have. If not, I'll stand down.
Anything further, Judge Gallagher?
No, thank you.
Judge Diaz?
Oh, thank you.
Thank you very much, Mr. Grimes. This case will be submitted. Madam Clerk? Be a good time for another break.
The court will take a brief break before hearing the next case.
Thank you.
United States Court of Appeals for the Fourth Circuit.
Our final case of the day is number 196523, Burke versus Clark. Mr. Harawa, you represent the
good morning,
plaintiff?
Yes, Your Honor. Good morning.
Good to have you with us.
And it's great to be with you virtually, Your Honor. And may it please the court, Daniel Scott Harawa, on behalf of the appellant Randy Burke, I'd like to reserve 5 minutes for rebuttal. Your Honor, Randy Burke was forced to live in quasi-solitary confinement for over 4 years simply because he would not cut his hair, as that would violate his religion. Virginia Department of Corrections grooming policy and its confinement of Mr. Burke in the admittedly punitive violators housing unit placed a substantial burden on Mr. Burke's religious practice in violation of RLUIPA and the First Amendment. On appeal, VDOC doesn't challenge the idea that the grooming policy and the VHU placed a substantial burden on Mr. Burke's religious practice, and therefore they forfeit any argument in response. Instead, VDOC argues that Mr. Burke didn't raise this claim below, but that's just thoroughly belied by the record. So I'd point this court to JA 18, paragraph 36 of the complaint, where Mr. Burke specifically states that his placement in the VHU violated his First Amendment, RLUIPA, and Equal Protection Clause rights. I'd point this court to JA 23, paragraph 61 of his complaint, where Mr. Burke specifically stated that the grooming policy punished him for his religious beliefs in violation of the First Amendment, RLUIPA, and Equal Protection Clause rights. And then on JA 24, in his prayer for relief, Mr. Burke specifically requested a declaration that the application of the grooming policy as to him violated his religious rights in violation of RLUIPA, First Amendment, and the Equal Protection Clause.
Mr. Laura, this is Judge Diaz. Can you hear me?
Yes, sir.
So you pointed out in 3 separate instances in the complaint where he clearly alleges a violation of the grooming policy, but I understood the Commonwealth's argument to be that your client failed to exhaust his administrative remedies because he didn't mention the grooming policy when he filed his informal complaints or regular grievances, at least not the first set, and that works a waiver because of the failure to exhaust. So can you address that?
Your Honor, I think my reading of VDOC's brief is that it's not an exhaustion of administrative remedies in the prison that VDOC is alleging. Rather, it's an argument that Mr. Burke did not present this argument to the district court. And in fact, if you look at VDOC's brief, they say that because the magistrate judge didn't expressly address this argument, that he must not have raised this argument in the district court. So I don't think VDOC actually raised an administrative exhaustion type argument in regards to the RLUIPA. I thought they argued that Mr. Burke never made a challenge like this prior to the appeal, and therefore he failed to preserve the argument. I thought that was in the response brief. Am I misreading that? I'm sorry, Your Honor. So the way I read the brief is that Virginia was arguing that he didn't raise this argument in the district court before he appealed his case to this court. Not that he didn't raise this. Well, okay, but even if they didn't raise it, I suppose that's sort of, I think, at least an argument that that's a jurisdictional question as a prerequisite to our considering it. Let's assume for the moment that their argument is much more expansive. Do you concede that the first time that this grooming policy argument appears is in the complaint? No, Your Honor, not at all. I think if you look at the grievances, which I'm turning to it now, if you look at page 107 of the joint appendix, so most of his grievances are listed from pages, I'm sorry, I'm just pulling it up, Your Honor, 97 to 98, 99, 100, and he mentions the grooming policy numerous times throughout these grievances. He also mentions the religious policy, which requires housing in the violators housing unit if you cannot comply with the grooming policy. So this is consistent throughout his grievances in the record. And in fact, the district court, when ruling on Mr. Burke's, or ruling on the defendant's summary judgment motion, the district court never held that Mr. Burke failed to exhaust his administrative remedies. Rather, the district court held that Mr. Burke that this grooming policy and the VHU did not place a substantial burden on Mr. Burke's religious practice. So I don't think it's the case that this argument was not presented to the prison. And I think, in fact, Mr. Burke filed numerous grievances, as VDOC admits, regarding his housing in the VHU. He attaches numerous affidavits from other Rastafarian inmates who are housed in the VHU and how they're being punished for this. So this has always been the crux of Mr. Burke's claim from the very beginning on this case. And the fact that Virginia didn't argue this administrative remedy exhaustion type argument, in fact, the district court didn't address this argument, I think shows that this argument is properly exhausted, and it was clearly raised in the district court below. And then the only other argument that VDOC makes in response to the First Amendment and RLUIPA claims is that the claims are moot, but that's clearly that doesn't apply to the First Amendment claim, as that includes a request for damages. But Virginia also can't satisfy its heavy burden of meeting mootness in this situation, because as this court said in Wall v. Wade and Porter v. Clark, that when VDOC changes its policies during the course of litigation, where nothing prevents VDOC from going back to that policy, which is the case here, that this court won't find mootness, or won't find that VDOC met its burden of proving mootness. And so I think, given those clear precedents and their clear application here, it's clear that this case isn't moot. It's clear that Mr. Burke raised this argument in the district court, and therefore this court should review this argument on its merit. And as the
Judge Gallagher. Sorry.
I'm sorry, Judge Gallagher.
So you say that it's clear that he raised the arguments below, but the two separate judges that were reading the complaint and addressed the complaint and the decisions, neither one specifically interpreted his claims as including an impossible choice argument. Is that correct?
Well, Your Honor, I think Judge Kaiser's opinion is a little bit unclear on this point. But Judge Kaiser does say that Mr. Burke has produced evidence of a substantial burden on his religious practice. And Judge Kaiser, in his opinion, also discusses the VHU and how Mr. Burke is housed in the VHU because of his religious beliefs. So while I don't think the opinion is necessarily the most detailed as to that point, I do think Judge Kaiser recognized the substantial burden point when it denied VDOC's initial motion for summary judgment. Now, in the second motion for summary judgment, the magistrate judge did not address this argument, but that was in part because she found that, A, Mr. Burke's religious beliefs weren't sincere, an argument that VDOC refuses to press now, and then she said there just wasn't any kind of substantial burden on his exercise. But I think what is most telling as to this point is that when this court requested briefing in this case, it specifically acknowledged or asked for briefing on the question of whether this grooming policy in the VHU placed a substantial burden on Mr. Burke's religious practice, which is completely consistent with this court's statement that its goal is to discern the intent of the litigant, and especially pro se litigants whose pleadings must be construed broadly. And it's clear from all of Mr. Burke's pleadings that he was saying he was being punished for his religious practice. The punishment in question was his housing in VHU and all of the restrictions that flowed from it. And so I do think, despite the district court's holding, I think a careful reading of Mr. Burke's pleadings, or even a cursory reading of Mr. Burke's pleadings, raises this argument squarely, and this court recognized that when it requested briefing on the argument. I'd like yes, Your Honor.
Prior to you being assigned to the case by this court, did Mr. Burke ever have counsel in this case?
No, Your Honor. Mr. Burke never had counsel in the district court.
He was pro se all the time up to you got in.
Yes,
you and your colleagues at University of St. Louis.
Yes, Your Honor.
Thank you.
Thank you, Your Honor. And then I'd like to turn to the Equal Protection Clause claim and explain why Mr. Burke, why it was inappropriate for the magistrate judge to grant summary judgment on this claim, especially after Judge Kaiser found that summary judgment was inappropriate. First, turning to the grooming policy, while the grooming policy is neutral on its face, an application had the effect of punishing Rastafarian inmates for practicing their religious beliefs. And we know, and we've seen time and again, that a neutral policy that targets a certain group of people can violate the Equal Protection Clause, and that's exactly what happened here. And in fact, Judge Kaiser, in his opinion, said that the VHU is reserved for inmates who refuse to cut their dreadlocks in violation of their religion. So Judge Kaiser understood the VHU as being home for Rastafarians who couldn't comply with the grooming policy. If this court looks or takes notice of Greenhill v. Clark, a prison official in that case said the VHU was reserved for Rastafarians. And then in an official VDOC policy paper, VDOC expressly notes that Rastafarians must comply with the grooming policy, despite the fact that numerous other religions could potentially be required to grow their hair or grow their beards in a way that would violate the policy. So it's clear that VDOC was targeting Rastafarians through the use of this grooming policy and their placement in the VHU. And this kind of differential treatment is only confirmed by the fact that Rastafarians just did not have the same opportunities to practice their religion as were given to other inmates in that prison. So, for example, there were no religious implements that Rastafarians could use to practice their religion, despite the fact that VDOC had available all kinds of implements for all sorts of religions, both that were donated, but also that VDOC carried for sale. And VDOC never housed or never carried any Rastafarian items.
So, Judge Diaz, can I ask a question about the policies you just talked about?
I guess
identified the Rastafarians as being impacted by the segregation policy. Is that? I mean, that's the evidence that you have with respect to intent, which I guess you have to show for equal protection claim. Isn't it more reasonable to read those policies as simply recognizing that the grooming policy had a discriminatory impact on Rastafarians, not necessarily that there was a discriminatory intent?
Your Honor, I don't think so, and that's for a couple of reasons. One is that the discriminatory impact operated just by the fact that the grooming policy was in existence, period. But the fact that VDOC specifically targeted Rastafarians on an official VDOC document saying that they, in fact, must follow the grooming policy shows that they intended for this grooming policy to, or at least there's strong evidence that they intended for this grooming policy to apply to Rastafarians in ways that it did not apply for inmates of other religions. And then if you look at other aspects of VDOC's policy, so for example, JA 361, which is VDOC Operating Procedure 84 1.3, which is the Offender Religious Programs document, it says that VDOC can restrict religious practice for failing to adhere to grooming requirements. And so the fact that VDOC knows that it is punishing people for not complying with the grooming policies, and then on top of that, the fact that VDOC specifically targets Rastafarians for compliance with the grooming policy, I think those two things together can give rise to an inference of discriminatory intent. And I think that's even more clear when you just look at the lack of resources available to Rastafarians in the prison to practice the religion in comparison with other religions in that prison. And so that goes not only to religious implements, it also goes to religious faith services. It goes to religious holidays and what meals and special services are available. And at every turn, Rastafarians received less than many of the other religions in the prison. And they're, on this record, VDOC has not produced any justification for why it treated Rastafarians so differently. And in fact, they only say that Mr. Burke never filled out the correct form, which if you look at the request to attend religious services form, there is no ability to request a Rastafarian religious service. And because Mr. Burke was in the phase 1 of the VHU, he actually wasn't eligible to attend group religious services. VDOC says Mr. Burke did not fill out the right form to request religious items, but if you look at JA 31, he did fill out an offender request form requesting the items, and VDOC never points to any other form that Mr. Burke should have filled out. And VDOC cannot say that Mr. Burke never made the prison aware of the fact that he was just trying to practice his religion. And the fact that VDOC didn't have anything for Rastafarians to practice the religion in this prison, given all of the other implements it has, and given the fact that it has a sizable Rastafarian population, I think at this juncture should be enough to overcome summary judgment with regard to the question of intentional discrimination. And Your Honor, I see I'm coming up at the end of my 15 minutes, but I would just like to remind this court that Mr. Burke was literally placed in solitary confinement just because he wanted to practice his religion. And if this court looks at its decision in Porter v. Clark, where it discusses how death row inmates were housed in Virginia Department of Corrections facilities, the VHU operated exactly the same, with the same kinds of restrictions as death row. And that's all because Mr. Burke grew his hair in accordance with his religion. And as the district court initially found before the magistrate judge issued her opinion, this was a place of substantial burden on Mr. Burke's religious practice. And he also, summary judgment was also inappropriate on the Equal Protection Clause ground. Thank you.
Thank you, sir. We appreciate it. Ms. Samuels?
Yes, Your Honor.
You represent the defendants?
Yes.
Pleased to hear from you. Thank you.
Thank you. Good morning, Your Honors, and may it please the court. Jessica Samuels for the appellees. Mr. Burke's complaint in this case asserted two sets of claims that are before this court on appeal. One, violation of his rights to freely exercise his religious beliefs, and two, intentional discrimination in violation of the Equal Protection Clause. On the record presented below, the district court properly granted summary judgment on both sets of claims. This court should affirm that judgment for three reasons. First, the free exercise theory that counsel now presses on appeal was not raised below. Second, even if Mr. Burke had asserted a challenge to the grooming policy based on an impossible choice theory before the district court, that claim would now be moot. And third, the district court correctly concluded that the claims Mr. Burke did raise failed as a matter of law on the evidence presented. To begin with the free exercise claims, both the briefing and counsel's argument this morning make clear that the nature of these claims has shifted dramatically from what was before the district court. Throughout the proceedings below, Mr. Burke's pleadings consistently identified three ways in which he was allegedly not able to freely exercise his religious beliefs. One, group services, two, religious items, and three, holiday meals. Those are the issues that the department addressed in its summary judgment papers, and those are the issues that the district court addressed in its opinions. The grievances to which counsel points this morning were importantly not the ones that Mr. Burke chose to attach to his complaint. And that's important, Your Honors, because a plaintiff is the master of his complaint, even if pro se. And of all the grievances that Mr. Burke submitted and then appealed, which are in the record, as counsel noted, he chose certain of those grievances to attach to his complaint and to pursue in his federal court litigation. And the grievances...
Judge Diaz here. I just want to be clear. I asked your friend on the other side this question, and it doesn't sound like you disagree with him, but this is not an appeal about exhaustion. It's an appeal about failing to plead in the district court. Is that right?
That's correct, Your Honor.
Okay. Go ahead.
I think it's helpful to look at the complaint the way that my friend on the other side did this morning. We can start at the very beginning, which is JA 11. This is the form that Mr. Burke filed to initiate his lawsuit, the complaint form. And he clearly lays out separate claims, and his religious exercise claim says defendants violated my rights to Rastafarian religious services, service items, and religious holy day meals. He's not challenging the grooming policy. He's not challenging the violators housing unit. He's asking for access to three different items, three different things. And for the reasons we've explained, and I'm happy to discuss with the court this morning, nothing about those items that he's requesting impose a substantial burden on his free exercise of religion. As counsel notes, the point of the pro se standard is to discern the intent of a litigant. And looking at this pleading is the best way to do that, Your Honors. And when you read through the pleading consistently, Mr. Burke is asking about services, items, and meals. That's the argument that the department addressed in its summary judgment papers. And that's the argument that both of the district court opinions considered. The timing here is also important, Your Honor, because the impossible choice theory that counsel now relies on, it wasn't new at the time, and so it's not something that would have been foreign to the district court or to the department, because it was being litigated in the Greenhill case at exactly the same time. When you look at the way the procedural histories of these cases lined up, the Greenhill decision, the second opinion in that case, was in September of 2018, and the second opinion in this case was in March of 2019. And so the department was well aware of these arguments, and the district court...
again, sorry. So I'm looking at the pro se complaint, and you did correctly point out sort of the primary focus of the complaint. But Judge King pointed out, rightly so, that the plaintiff in this case was pro se up until the moment of this appeal. And so we do obviously take a pro se litigant and give him a fairly wide berth in terms of pleading and the like. I mean, he does throughout this complaint sort of identify that he's complaining about the defendants and identifies the defendants in paragraphs 4 and 5 who are responsible for placing people in violator housing units for people who, quote, refuse to cut their hair because of Rastafarian religious beliefs. He does that at paragraph 4. He does it again in paragraph 6. And in paragraph 16 of the complaint, he says, at Red State Prison, I was placed in segregation for not being in compliance with the Virginia Department of Corrections grooming standards because of my dreadlocks. I mean, and then in the legal claims, he talks about, he identifies the legal claims. Isn't that enough? I mean, we don't demand legal perfection of pro se litigants. It's clear that he's sprinkled this complaint throughout his pleading. Why isn't that enough?
Well, Your Honor, I think that the most important thing here is to remember that the special solicitude with which we construe pro se pleadings, which of course the department doesn't challenge here, but it does have a limit, and the limit is to discern the intent of what a litigant was challenging. And so to say that it was sprinkled throughout here enough, I think the appropriate lens to look at that through is what he was asking for, and he was asking for services, items, and meals. And I think JA 23, to which my friend on the other side points, is a helpful way to look at that, where the complaint notes that it does note the grooming policy, the operating procedure, but then he notes that the reason he's complaining about it is because it denies him access to group services, items, and meals. And so when you read through the complaint, those are the things he's asking for. And so I think that's the most helpful lens instead of are there enough references here or there. I think it's also helpful on that same note, Your Honor, that this is not a complaint where it's not clear what he's challenging or what he's seeking, or where it's ambiguous and he invokes several different provisions and several different claims, and the district court has to figure out what he's challenging. The department briefed summary judgment twice, and the district court wrote 2 opinions. And Your Honor, to say now that the complaint adequately raised this claim, I think it would be fair to say that then the department and the district court just missed it. And so I think that that's a helpful understanding of what was and wasn't raised in terms of everyone who was looking at this pleading and trying to figure out what it said. On that same note, Your Honor, even if you don't agree with me and you think that is enough, I do think it's important to note that grooming policy that counsel has focused on this morning is no longer in effect, and so any injunctive claims on that would be moot. So to the extent this court is inclined to find that the grooming policy was adequately raised below and to remand on that basis, the prior policy that's been challenged, the claims on that would be moot, and so we would urge the court to at least agree with us on the mootness argument and send it back on a limited basis. But again, we don't concede that. We think it's not raised, and we don't think it's fair to.
This Judge King, your friend there on the other side says it's not moot because you can change it back tomorrow the way it was before. So we need to rule on it. He doesn't buy into your mootness claim.
Yes, Your Honor. We have several responses to that. The first is that this change in policy was not just an overnight flip of the switch. And the department adopted an entirely new department-wide policy that involves rigorous procedures and is not something that can change overnight. I think that's the first important fact on the mootness analysis. The second is that...
Has he been moved out of the solitary confinement?
He's been moved out of the violators housing unit. Yes, Your Honor.
He was in there 4 years because he wouldn't comply with your mandate that he cut his hair, correct?
Yes, Your Honor.
And you didn't challenge the proposition that the Rastafarian religion required him to leave his hair alone.
That's correct. We have not challenged that. The new policy, however, was enacted in June of 2019, which that timing is important because you can't draw a through line from this litigation and Mr. Burke's claims, even assuming he's raised the grooming policy, to the department's changing of its policy. And I think that's a very important fact for the voluntary cessation analysis. Another important fact is that the department in this briefing and before this court has expressly disclaimed any intent of changing the policy back to the old one. And so I think that also sets this case and these circumstances apart from some of the court's precedent that counsel has cited this morning.
Where is that? I mean, you're saying it here today, but is that, you said it's in the briefing and in the record. Where is that?
Yes, Your Honor. It's in our brief at page 33 and 34.
So you are representing on behalf of the...
I'm sorry. Go ahead, Judge Zia.
You're representing on behalf of the Commonwealth of Virginia that you do not intend to revert back to this policy, period?
Your Honor, we are representing that defendants disclaim any intent of doing so.
Well, I mean, the sort of the language that's the principle of law that you have to abide by is it has to be absolutely clear that this allegedly wrongful behavior won't be repeated, won't be expected to recur. And you're suggesting that because of the sort of the time and effort it takes to reinstitute the policy and the representations in the record and in the brief that's good enough? That satisfies that doctrine?
That is our position, Your Honor, but I think there's more. I think there are at least two other reasons that we can be assured that standard isn't met here. The first is that if you look at the history of the grooming policy, it has consistently become more lenient and allowed more hairstyles and offender conduct, not less. It's not becoming more restrictive. And I think that history is important, and that history is important against the backdrop of the evolving legal landscape on these issues and the department's good faith attempt to comply with that. And on that note, this court is well aware of the Greenhill precedent that my friend on the other side has raised. And so to the extent that going back to the old policy would raise questions, at least under RLUIPA, I think that's another, that potentially adverse precedent weighs in favor of the department here and weighs against a finding that there's any reason to believe the department is inclined to just flip a switch and go back to the old policy, particularly in light of the fact that Mr. Burke has not just been transferred out of the violators housing unit, just him, as might be alleged to try to evade liability on this one litigation. The whole unit has been shut down and abolished. And so this isn't like one of those cases where it's easy enough to change something to try to wait out a lawsuit and then be able to go back overnight. But those just aren't the circumstances here, given the context of the department-wide policy and the evolution of that policy.
When you say the unit's been shut down and abolished, you mean that this unit at what's this, Wallace Hills or something?
The violators housing unit at Wallens Ridge. Yes, Your Honor. That when the grooming.
Do they have a unit at some other prison like this?
There's no more violators housing unit. No, Your Honor. When the
nowhere in the system.
That's correct. When the grooming policy changed in June of 2019, a specific special housing unit for offenders of the policy is no longer part of the department's procedures. And you can see that in the addendum to our brief, which includes the new policy. And at the addendum at page 5 explains how it says all offenders that are in the grooming standards violators housing unit shall be transferred out to a suitable institution.
Ms. Sanders, you brought up the Greenhill case, and I know your first argument is that this claim regarding the grooming policy hasn't been properly preserved. But assuming we get past that and we think that it has been, you can see that under Greenhill, this policy as it existed before you changed it would in fact and did in fact impose a substantial burden on Mr. Burke's religion.
Your Honor, we think that question wasn't raised before the district court as discussed, and for that reason, we think if that is what the court is inclined to do, that a remand is appropriate to litigate that question below in the way that Greenhill did. So we are not prepared to take a position on that here because it wasn't presented to the district court.
That's a bit problematic then, because if you say that, then it suggests to me that this claim is not moot if you're not willing to concede that point.
Well, Your Honor, we're willing to concede that Greenhill absolutely applies and is absolutely binding. I guess our point is that Greenhill was, its own facts, and the district court in Greenhill remanded for further evaluation. And so we think that would be the appropriate course here if the court were to find that the grooming policy challenge had been raised.
All right, go ahead.
Thank you. I think it might be helpful, Your Honors, with the time we have left to discuss the claims that were presented below in our view. The RLUIPA and First Amendment claims as applied to the religious services items and holiday meals, the district court properly found that Mr. Burke had failed to show that these defendants imposed a substantial burden on his faith. The undisputed evidence shows that the defendants did not, in fact, deny Mr. Burke access to the items that he identified. Instead, he didn't submit the proper requests and comply with the proper policies. And I think it's important to note, Your Honors, that this is not just a matter of paperwork or needing to shuffle papers to get what Mr. Burke needs, but these policies are important and have important penological ends and justifications, and that they also work. I think if you look at, to take just one example, the list of approved religious items, which there's an example of the list at JA 277, you can see there are several items that are available. And if you look at JA 279, you can see where a new item, the Native American drum, was added, and it has the date that it was added. And so the idea that Mr. Burke was just getting stonewalled at every turn it is inconsistent with the record because there is evidence in this record, and defendants have pointed to it, that there are processes in place for the purposes of preserving prison security, prison safety, inmate and staff safety that inmates need to comply with, and that those policies are meant to balance these goals and to make sure that VDOC can facilitate inmates' religious practice while also balancing these other important considerations. And so the question here is whether Mr. Burke was denied access to those claims, and in response, he points to a form that he submitted, which is at JA 40, is the religious services form. And VDOC's response is there's no hearing because all you need to do is enroll. And there's an enrollment form. There was an open enrollment period provided every quarter where you could change your enrollment or take yourself off of the list. And it's easy to understand, Your Honors, why in the context, the unique institutional context of a prison, that the prison officials would need to know who was signed up to go to which services, and that asking Mr. Burke to complete that form is not a substantial burden. And at no point has Mr. Burke either presented evidence or pointed to evidence that he did submit the proper forms. I think that's important to note what he's arguing. My friend on the other side this morning said that suggested there was no form to request approval of a religious object. That is in the record at JA 426. We have no evidence that Mr. Burke did ever submit that. And so, while it can be, we understand the frustration in terms of trying to comply with these policies, but the evidence in the record shows that it was clear what Mr. Burke was needed to do to access these things, and that there's no evidence that he did. And on that record evidence, that there's no finding of a substantial burden on these claims. Turning to the equal protection piece of things, in the briefing and here this morning, counsel concedes that the grooming policy and the procedures for acquiring religious services and religious items applied to all offenders equally. They didn't single out any one group. They didn't single out any particular religion. They applied across the board to all offenders at the department. Counsel points to the form J274 that notes Rastafarians must follow DOC grooming standards. I'll just note, Your Honor, this form is, first of all, not part of the grooming policy. It's part of the religious, it's an attachment to the religious programs operating procedure. So it, of course, can't change or doesn't change the grooming policy. But more importantly, nothing about this form or the parenthetical to which counsel points notes that Rastafarians are the only ones who have to comply with the grooming policy. I think it's better understood as a note that by being on this list of religions that are approved to meet, that in no way excludes or exempts Rastafarians or any other religion from the otherwise generally applicable grooming policy that existed. If there are no further questions, Your Honor, appellees ask that this court affirm the district court's award of summary judgment as to both the free exercise claims and the equal protection claims. Thank you.
Thank you, Ms. Samuels. Mr. Harawa?
Thank you, Your Honors. So I just want to make very clear that Mr. Burke most certainly raised his claim, and I want to read directly from his complaint. So if you look at the prayer for relief, which is on JA24, paragraph 3, Mr. Burke specifically requests, and I quote, a declaration that the acts and omissions of the Virginia Department of Corrections grooming policy of the operation of 86.4.1 as applied to plaintiff is in direct violation of his Rastafarian religious rights under the Religious Land Use and Institutionalized Persons Act and the First Amendment Free Exercise Clause. So there he is expressly saying that this grooming policy violated his First Amendment and the LUPA rights. And then if you look at JA 283, again, Mr. Burke expressly argued that he was being punished for his religious practice. And I'll briefly quote, according to the 86.4.1 operating procedure, the violator's housing unit was designated to be at Wallens Ridge to discourage inmates from growing hair longer than the length allowed in the policy. This prohibited plaintiff from being employed in the kitchen, laundry services. Plaintiff grows his hair as necessary for his religion. Therefore, defendants are punishing the plaintiff for being religious. So Mr. Burke makes very clear that the operation of this policy and the creation of the VHU was punishment for him exercising his religious belief, which is most certainly a substantial burden. Now, what I think my friend said on the other side is telling of why this case isn't moot. So it's not enough for VDOC just to say that I think the words were disclaimed any intention. What this court's cases say is that you have to consider yourself prohibited from returning to this policy to establish mootness, and clearly that's not the case. Opposing counsel didn't say that VDOC recognizes that this policy places substantial burden on Mr. Burke, so would never go back to it, which is what would be needed to prove mootness, because as this court said in Wall v. Wade, unsubstantiated appellate promises aside, we have previously held that when a defendant retains the authority and capacity to repeat an alleged harm, a plaintiff's case should not be dismissed as moot. So I think the Virginia Department of Corrections hasn't met its heavy burden of proving mootness here, and so therefore this court should address the RLUIPA claim as well. In terms of the religious items and kind of the singling out of Rastafarians by VDOT, I just think it is the least plausible reading of that document to say that this wasn't any kind of affixing upon Rastafarian inmates with kind of specialized attention or kind of a specialized focus for this grooming policy. It just doesn't make sense given the fact that some Jewish sects have to grow their hair. Some Native American religions require hair growth. Some Muslim sects require growth of beards. There are so many religions that require hair growth or that could run afoul of the grooming policy. And so the fact that VDOT singles out Rastafarians just doesn't pass the smell test. And in fact, as Judge Kaiser said, the whole violators housing unit, in his words, was designed to house people who could not cut their dreadlocks in violation of their religious beliefs. And that is specifically targeted towards Rastafarians. Regarding the request for religious services, I think it's really important to note at JA 345 that Mr. Burke was ineligible for group religious services by virtue of the fact that he was in the VHU. So it's simply not the case that he didn't fill out the right form. And in fact, Virginia VDOC's policies banned him from religious services. And I think it's telling the fact that Mr. Burke requested items over and over again through all different mechanisms and channels. And not once did a single person in the Virginia Department of Corrections tell Mr. Burke that you filled out the wrong form or that you need to fill out this form. Instead, he was in fact stonewalled. And I think given the breadth of other objects that VDOC has for other religions, I actually think that works against the prison in this instance because it does show that efforts weren't made to allow Rastafarian inmates to practice their religion in the same way that other religions were allowed to practice.
Mr. O'Rourke,
yes, Your Honor.
Can you tell us how many Rastafarians are in the Virginia prison system?
Your Honor, I don't know the exact number, but I do know based on the affidavits that Mr. Burke submitted just in this suit that there are at least 7 in Wallenbridge at the time he submitted his complaint with the attached affidavit. And I think the fact that the prison created a whole unit for Rastafarian inmates shows there was a substantial population, which really quickly going to another point, Virginia policy, its own policy states that if there are more than 5 people of a religion, then there's a presumption that they will be provided group services. And again, for whatever reason, the prison didn't abide by that policy when it came to Rastafarian inmates. So I think there's just too much on this record that goes to show that Rastafarians weren't allowed to fully practice their religion and in fact were punished through the use of solitary confinement for practicing their religion, that their religious practice was certainly burdened substantially by the prison's policies. And in fact, there's enough here to raise an equal protection clause claim such that summary judgment at this juncture was inappropriate. Now, trial may turn out something different, but I think at this stage, this court should reverse the district court. Thank you.
Very good. Thank you. And Mr. Huala, you're court assigned, and I want to express the appreciation of our court, not just for you, but for the law students that worked with you and assisted you with this case.
Thank you, Your Honor.
I really appreciate it. Thank you. Judge Gregory, be proud of you, sir.
I'm gonna quote that, Judge.
Madam Clerk.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.